Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Mistrial. Ridiculous the insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcake's sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends. Hello. Thank you so much for coming to hang out with me. Today is Friday, December 6th. It is about 12:15 p.m. on the East Coast here in New York. And some breaking news on the Daniel Penny case. There may be a hung jury. Things are changing minute to minute. So what recently happened just a few moments ago, the jury sent out a note saying that they were deadlocked. The judge called in both sides to talk about it. And I'm going to tell you what happened. But the jury has just been sent back out after being given the Allen charge. So there's a couple of things that I want to go over with you while we wait. Because as you know, this could happen at any minute. It could happen 20 minutes from now. The jury could come back and say we're still deadlocked, and the judge could grant a mistrial. Or the jury could go out for 20 minutes and then come back with a verdict. So we don't know. I figure we might as well wait together, as we often do, for a verdict watch. And it's kind of crazy. I mean, a lot of people were talking yesterday that there may be a mistrial, that there may be a hung jury. And I was saying, no, it's too soon. It's too soon. Today is only day 4 of deliberations. And this is a case that's going to have chilling ripple effects throughout not just New York, but nationwide. This is a case of self-defense. This is a case of Good Samaritan stepping up to, in my opinion, protect an entire subway car full of people. And depending on what happens today, and a lot of people have been saying with this verdict, that if Daniel Penny is found guilty, nobody's going to step in to help anybody anymore, especially in New York City. So let's take a look. First thing I want to do is take a look at the verdict slip. I've been following, and I told you guys to also follow Inner City Press on Twitter for breaking news, and he has been amazing throughout this trial. He's really the only person who's live tweeting from inside the courtroom with such precision that he's been my go-to on this. So let's just take a look at what he's been saying for the past half an hour or so. And as you know, there are no cameras in the courtroom. In fact, the day that I went to court on this case, which was one of the first days of trial, and I was waiting in the hallway, and I, took some video of Daniel Penny just walking out of the courtroom. And after that happened, the court officer kind of, he didn't jump on me, but he was kind of like, all right, come, you got to delete that video. You're not allowed to take video in the hallway. And I'm like, but there's cameramen right over there. And he's like, yeah, but in case the jurors come out, so he made me delete the video. That was a thing that we talked about. But so there are no cameras in the courtroom. So we're relying on guys like Inner City Press, who's in the courtroom, to tell us what is happening. And here's his Twitter feed. He also has written a book. So here we have to kind of go backwards on this. And I want to start with the jury went out earlier this morning, and this is day 4 of deliberations. And so this was posted about 11:41 a.m., which goes 12:18. So this was just a little over half an hour ago. The Daniel Penny jury says no unanimity on count 1. So the judge was mulling over whether or not to give the Allen charge on count 2. We're going to look at the verdict sheet in a minute. And where's that thread? Now I can't find it. Now I can't find it. All right, here we go. So as of 29 minutes ago, Daniel Penny and his lawyers walk in. This was after the jury sent out a note saying that they were deadlocked. Come to order. Judge Wiley says, what's the defense position? Penny's lawyer, Kenneth, says, we're moving for a mistrial, judge, after 20 hours of deliberations over 4 days in a case that is not factually complex. He says, we oppose the Allen charge as coercive. The ADA, who's trying this case, Daphne Uren, says we want the Allen charge and we may be willing to dismiss count 1 to get them to count 2. Well, that's interesting. Judge Wiley says they may hang on both. Over the defense objection, I will give the Allen charge. So right away, the defense is coming in saying we want a mistrial. And typically what the judge will do in a case like this is grant the Allen charge. The Allen charge is like the last ditch effort to try and get the jury to reach a verdict. I'm going to read to you the New York Allen charge. It's also in Massachusetts. If you're following Karen Reed case with me, they call it the Tui Rodriguez charge. It's kind of like, we know you guys are the best. You're the best jury for this case. If anybody can come to a decision, you guys can come to a decision. Please go back and try one more time. So I'll read that to you in a second. Then the judge says, you were 12 selected to serve. Both sides expressed confidence in your fairness. There's no reason to think a future jury would be more intelligent or hardworking. I'm going to read to you the pattern Allen charge, which is what I think he's referring to here and trying to transcribe word for word. But since I have it, we might as well go over the whole thing. And 16 minutes ago, the jury exited. And the judge said, I think they can go on to count 2. Which is interesting because the verdict slip, as we're going to look at right now, says that if you do not come to a verdict on count 1, do not go on to count 2. So again, we're going to look at a confusing verdict slip or verdict sheet. And we're going to see if while we're live here right now, they're going to come back with either a verdict or another note telling the judge that they are indeed hung. And what will happen after that. Here's the verdict sheet. I have the Canton Leaf Blower Society outside my window, so hopefully you can't hear that because it's wicked loud. Okay, here is the verdict sheet. People of the state of New York versus Daniel Penny. Indictment number, and this is in the Supreme Court of the state of New York, County of New York, Part 54, Judge Wiley, Judge Maxwell Wiley. Count 1. This is what the jury is sent back with to fill out. Count 1, manslaughter in the second degree. That's the top charge. And here it says, if you find, let me get my red pen out. If you find the the defendant guilty of count 1, manslaughter in the second degree, then do not consider and do not render a verdict on count 2, criminally negligent homicide. If you find the defendant not guilty of count 1, manslaughter in the second degree, for the reason that the people have failed to prove beyond a reasonable doubt that the defendant was not justified, then you must not consider count 2, criminally negligent homicide, and you must also find the defendant guilty of that count. I'm sorry, you must also find the defendant not guilty of that count. So it's confusing. Again, even as an attorney, it's confusing. If you find the defendant guilty of count 1, manslaughter, then do not go on to count 2. If you find the defendant not guilty of count 1, manslaughter, then you must not consider count 2, criminally negligent homicide. And you must also find the defendant not guilty of count 2. If you find the defendant not guilty of count 1, manslaughter in the second degree, for some reason other than the lack of justification, then proceed to consider and render a verdict on count 2, criminally negligent homicide. Right, it's confusing. For some reason other than the lack of justification, like other than the lack of self-defense. Count 2 is criminally negligent homicide, which was defined for the jury. And they came back several times yesterday asking for readbacks and asking for definitions and asking for jury instructions to come back with them. And that was granted. What it does not say here is if you cannot come to a verdict on count 1, go on to count 2. And this is what the judge was mulling over in court with the attorneys. Well, just because they're hung on count 1 doesn't mean they can't move on to count 2 and find him guilty of criminally negligent homicide. You see the slippery slope here? We'll see what happens, but it is interesting. Moving on to the criminal procedure law, which may assist us somewhat, of New York, which is rendition of a partial verdict and effect thereof. Let's see if we can find any guidance here. And this is criminal procedure law 310, section 31070. Rendition of partial verdict and effect thereof. 1, if a deliberating jury declares that it has reached a verdict with respect to one or more, but not all of the offenses submitted to it, or with respect to one or more, but not all of the defendants, the court must proceed as follows. A, if the possibility of ultimate agreement with respect to the other submitted offenses or defendants is so small, and the circumstances are such that if they were only matters under consideration, the only matters under consideration, the court would be authorized to discharge the jury pursuant to paragraph A. But that is not at issue here because they are not saying that they've reached a verdict. They're saying that they're hung. So let's see and move on. Following the rendition of a partial verdict pursuant to subdivision 1, the defendant may be retried for any submitted offenses upon which the jury was unable to agree unless a verdict of conviction would have been inconsistent with the verdict. Well, no, they're saying they're hung right now. We may need to come back to this later. Because a hung jury is not a verdict. It's a hung jury. I'll just move now. Let me see if Fox Live is covering this, but nothing has happened as of yet. Let's take a look at the Allen charge that the judge did just read to the jury. And I'll read it to you. Members of the jury, I have your note indicating that you have been unable to agree on a verdict. As I told you in my initial instructions, any verdict you return on any count, whether guilty or not guilty, must be unanimous. If you cannot reach a unanimous agreement on a particular count, you cannot return a verdict on that count, and a new trial will have to be scheduled before a different jury. It is not, however, uncommon for a jury to have difficulty initially in reaching a unanimous verdict, and it is not uncommon for a jury to believe that they will never be able to reach a unanimous verdict. But after further deliberations, most juries are able to reach a unanimous verdict. And so I will ask you to continue your deliberations. But before I do, I want to remind you that when this trial began, many prospective jurors were called and questioned. Many were excused for one reason or another. But you, ladies and gentlemen, were selected to serve. This means that all of the prospective jurors called in this case, you were the ones in whom both sides expressed confidence. Both sides were convinced that each of you would be fair and impartial, that each of you would listen carefully to the evidence, to the arguments, and to the law, and that each of you would deliberate with your fellow jurors and work hard to reach a unanimous verdict that was consistent with the law and the evidence. Both sides continue to have confidence in you, as do I don't know what, as do we, I guess. Members of the jury, you make up a very good jury. There's no reason to believe that the presentation of this case, again, would be to a jury that is any more intelligent, reasonable, hardworking, or fair than you are. I want to emphasize that I'm not asking any juror to violate his or her conscience or to abandon his or her best judgment. Any verdict you reach must be the verdict of each juror, and not mere acquiescence in the conclusion of others. But I'm asking you to continue deliberating and to resume your deliberations with an open mind. Start with a fresh slate. Do not feel bound by how you felt before, whether you favored conviction or acquittal. Have the courage to be flexible. Be willing to change your position if reevaluation of the evidence convinces you that a change is appropriate. Do not, out of pride or stubbornness, adhere to an opinion or conclusion that you no longer believe is correct. Be honest with yourselves and with the other jurors. Listen to the other jurors and evaluate what they have to say. Do not let anything prevent you from carefully considering what they say. Remember that each of you made a commitment when you became a juror that requires you to reason and deliberate together to reach a fair and a just verdict based only on the evidence. Of course, while a discussion among all jurors may at times be intense, I'm sure you understand that it can and should also be respectful of the feelings and opinions of other jurors. I urge that each of you make every possible effort to arrive at a just verdict here. Make certain that the decision you reach is based solely on the evidence, on the law, and is not influenced or affected by sympathy for or against any individual or for or against either side. Be sure that no baseless speculation, no bias or prejudice for or against any individual enters into your deliberations. If I can help you in any way, whether through a further or repeated readback or through a clarification or restatement of the law, I stand ready to do so. Again, make every effort consistent with your conscience and the evidence in this case to harmonize your views and decisions in this case with those of the other jurors. To the best of your ability, I ask you to apply common sense and good judgment. Finally, ladies and gentlemen, I appreciate that the process of deliberations can be difficult. Frankly, it wasn't intended to be easy. So, in accord with your oath and your promise to me at the beginning of the trial, please continue to deliberate with a view towards reaching a verdict. And that, my friends, is the New York State pattern Allen or deadlock charge. Let's take a look at what happened just a few minutes ago. Fox was streaming live and they had a little more insight into this. So this is the most recent coverage that I'm going to be able to find for you.
Welcome back here on Live Now from Fox. The time 11:58 on the East Coast, and it is 8:58 on the West Coast. We do continue to follow this breaking news involving the trial for Daniel Penny. Now, the jury telling the judge that they could not reach a unanimous decision on count one of the charges against him in the subway chokehold trial. The judge is determining how to move forward and is deciding whether to give the jury an Allen charge. This is all developing at this hour, and this is just some of the video there of Daniel Penny as he entered into the courtroom. Now, I do want to bring in Jeremy Rosenthal. He is a trial attorney and has been joining us to discuss the case as it has been progressing. As always, Jeremy, thank you so much for taking the time to join us here.
Happy to be here. Thank you.
All right. So first off, I know this is all just coming out right now, but can you explain to me what a deadlock jury really is and what it means to say they are a hung jury here on that manslaughter charge?
The jury doesn't get to decide that they're hung. It's the judge that ultimately decides whether or not there's a hung jury. And that's because a jury trial is a massively expensive, terribly, I mean, you're not talking about just the person on trial. You're talking about all the witnesses, all the lawyers, all the jurors. In a trial like this, there are probably hundreds of people whose lives are implicated, and they want to get this thing to the finish line. So a lot of times what may happen is a jury may come out and they may say, Judge, we're not agreeing on this. We're not getting along. We're not able to decide this. And the judge almost always is going to send them back to keep deliberating. An Allen charge, or as we call it, a dynamite charge, is the court issuing a letter to the jury that says, we really need you guys to work harder towards a resolution. You know, stick to your guns. We want you to have, you know, we brought.
Okay, and even breaking further news, as of 12:26 p.m., it is right now 12:35, the ADA has come back in and has handed a note. Court officer says they're ready. Daniel Penny and his lawyers come in and get the note. The judge says, so we got the next note. This was just 4 minutes ago. It states, we, the jury, request further clarification on whether a person reasonably believes force is necessary. We would like more on what is a reasonable person. That's really interesting to me. And then the judge says, there's a passage in the People versus Getz. Remember Bernie Getz? And then he chuckles, in which they note that reasonableness must be based on circumstances. Maybe that will help. And then Penny's lawyer, Kenneth, says, we obviously know the Getz case very well. That's speaking to the subjective. So that was literally 3 minutes ago. That is a really interesting note. But the jury is really being thoughtful and they are continuing to ask for clarification. And to every judge out there who says, such as the judge in the Carly Gregg case, it's common knowledge what reasonable doubt is. I don't need to instruct them on reasonable doubt. I say, this jury wants to know what the definition of reasonableness is. Right? Let's continue with this coverage from a few minutes ago, and I'll continue to update you as the tweets come in.
Brought you into this jury so we could hear your opinions, and your opinion matters, and we want you to be independent, but not really. We really need you to listen to the guy next to you because we want a verdict here. If the jury is hung, And if it comes back, if they keep going back to the judge and back to the judge and back to the judge and just saying, look, we are just not going to reach a verdict here, the judge could declare a mistrial, and then we do this all again down the road. That can happen, but again, at the first outset, it's not uncommon for a jury to throw this out there, and then we do get a verdict sometime later in the day. That can still happen.
So that's what I was going to ask you, is how often do you see the jury then return and say, okay, well, let's discuss it a little bit further and actually come to a unanimous decision of sorts?
It's common to see the Allen Charge work. Juries hang all the time, but the Allen Charge, you just don't know the dynamics of what's going on in the jury room. You could be looking at 11-1 split, where you've got one person who's in the corner with their arms folded and everybody shouting at them. You don't know if it's 7-5 or 6-6, or maybe there are some undecided people in there. These folks have been asking for exhibits. They've been asking for all types of things that are sort of all over the map. We don't know who in that room is asking for what as far as exhibits go. So we just don't know. And sometimes if you have maybe one or two holdouts, sometimes that Allen Charge can push it over the top. But not always. Again, we just really have no way of knowing what's happening in that room right now.
How quick does that happen when you're talking about an Allen Charge and they do go back? Is that an instant thing? Does the judge just kind of think about it for a few minutes and say, no, go back? Or does it take a while?
It ought to be pretty quick. And the reason for that, anytime the judge is directly communicating with the jury, it's very precise and it's very curated. And the reason for that is because anything that the judge is communicating with the jury is a very big trigger point for a reversal on appeal. So you have to be very, very sterile when you communicate with the jury, very precise. And if you've seen one Allen Charge, you've seen them all. So you don't really need to reinvent the wheel when you're writing your Allen Charge. And it's going to have a few components in it that are going to be written as neutrally as possible. So an Allen Charge is something that is really literally copy and paste, put the name of this case on the top, write it, sign it, let the lawyer.
And if you're just tuning in, we just went over the Allen Charge. I read the entire thing. It's about 3 pages long.
In the courtroom look at it, give it to the panel, and then that's it. And sometimes the judge may bring the jury in to read the Allen Charge to kind of pound the table with it, or sometimes they just send it back. But again, I hate saying that this. It tells us what we already know, right? I mean, this deliberation has been several days already. That tells us that they're talking about a lot of things. When we were talking the other day, Josh, there's a lot of reasons to convict this guy, and there's a lot of reasons to acquit him. So it should be no shock that the jury's really struggling with this as well.
Yeah, I
Does
disagree.
it give any sort of, I guess, indication when you do hear that there's a deadlocked jury, that they are deadlocked as of right now? Does that give an indication as to which way they are leaning?
It just really doesn't. I mean, you would hope.
Okay, and as of 19 seconds ago, Judge Wiley says, bring him back out. Jury entering. Judge Wiley says to the jurors, reasonableness is up to you to decide. What would a reasonable person do in this situation? He must have honestly believed Jordan Neely was going to use physical force against him or someone else. So yeah, reasonableness is a subjective standard, and is going to be up to each juror to decide what is reasonable. And like I tell you, every single time we talk about jury trials, the jurors don't leave their common sense at the door. Many of these jurors, as we went over in another live stream on this case, have had altercations in the subway, have observed altercations in the subway, have been afraid for their life in the subway, ride the subway every single day. So many of the jurors on this trial have had those experiences. And so the fact that they wanted to know if there was a legal definition of reasonable is interesting. And now the judge is sending them back and saying, no, it's up to you to decide what's reasonable. You're the reasonable person standard. It's you. So that's interesting. I don't think it's going to take long. So we're going to hang out here and wait. This trial is not televised because we don't allow cameras in the courtroom in New York. That is why. Sad but true. I'll keep playing this.
To read something in there. Sometimes if the judge asks the panel to come back into the room to read it to them, you can sort of read facial expressions and you can try to see who's making eye contact, who's avoiding contact as far as the jurors are concerned. You can see a lot of times some frustrated body language. Sometimes if you ask the panel back into the room to read an exhibit, they'll look at each other or they'll look at one person who may be the holdout and you see body language. So it's not uncommon for the jurors to be frustrated with one another. And then you do sort of get a reading on that. It's unfortunate because you're really at that point, the evidence is closed and all the arguments are closed. So based on how that split is, you can't go back and argue to that same juror. Look, keep holding on here. You're right. We're going to win this if you keep in our corner. You can't quite do that, but you do get a better idea of where this breakdown may be.
When we talk about the declaration of a mistrial, for instance, how exactly does that work? Do we just go through everything all over again with the same witnesses, the same evidence, everything like that?
That's exactly right. Think of it like in terms of a baseball game. When you see the pitcher on the second at bat or the third at bat and the third go round, you have a better idea. So you can see that the lawyers are almost certainly going to plan differently the first time around and from the second time around because they will have already seen the pitch, if you will, from the other side.
Well, this is interesting because think about this in the Karen Reed case, the Karen Reed mistrial, and what that's going to mean for the second trial. So I'm going to play that back again.
Almost certainly going to have a better on the second at bat.
Everything like that. All trial, for instance. When we talk about the declaration of a mistrial, for instance, how exactly does that work? Do we just go through everything all over again with the same witnesses, the same evidence, everything like that?
That's exactly right. Think of it like in terms of a baseball game. When you see the pitcher on the second at bat or the third at bat and the third go round, you have a better idea. So you can see that the lawyers are almost certainly going to plan differently the first time around and from the second time around because they will have already seen the pitch, if you will, from the other side. A good example, too, that's in the news on another story is the Menendez brothers. They had initially a hung trial. The first go round and the second go round, the evidence that the judge allowed in that instance was quite different. First trial got
it was a
hung.
mess.
Second trial, the judge disallowed a lot of the defense evidence, and it resulted in a much quicker conviction, obviously. So you can count on the lawyers changing up their trial strategy as you would, again, a batter facing a pitcher and taking a different approach based on the second go around. But you do start over from scratch, essentially, and then we have to do this all over again.
And reports are indicating that the defense is calling for a mistrial. That would be probably fairly standard.
You would think. I mean, if they get a mistrial, every day that you are not convicted in a homicide case or a case like this, it's a win. I mean, part of you as a defense lawyer wants to push for that. You want to push and be done with it, and you want to push for a verdict. But at the same time, if you get a mistrial here and it's hung, then you can also go back to the prosecution and say, listen, this thing is just way too close. This is way too tight. Let's make some sort of a deal. My client has been through a lot already. You guys have been through a lot. Nobody wants to do this all again. So there is that temptation. And legally, I think the proper thing to do to preserve appeal is to ask for a mistrial at this point. But probably the judge refuses that, issues the Allen charge and says, all right, everybody, we're going to be patient. We're going to let these guys go at it a little longer and see what we get.
And right now, I guess it's kind of just a waiting game to see what happens next, right?
That's right. And look, I've seen Allen charges where the jury comes back 20 minutes after the Allen charge is issued with a verdict. I've seen that happen. I've also seen it happen, obviously, frequently where they come back and come back and come back. And after a while, they just certify that it's really futile. And the judge, like, are we really super sure here, guys? Okay, there's no way we're getting through this. Okay, then it's a mistrial. But it's the appropriate thing for the judge to take time and to try to push these jurors through these things, because again, they don't serve on juries every day. They're not professional jurors like the judge is a professional judge. We see this in the court system all the time, and we know that if you push, you're gonna get the case resolved at least a good percentage of the time. So there's no reason not to see if you just can't get this thing to the finish line.
All right, Jeremy Rosenthal, trial attorney. As always, thank you so much for taking the time to join us as we continue to follow this breaking news here, the jury deadlocked, so to speak. So, Jeremy, anything else you want to add before I let you go?
This is a real close case, and we talk about it all the time. It's emotions that drive these things, and people will, their emotions are how they see the facts. So we debate these things, and we look at the pros and the cons and all the evidence and what this witness means and what that witness means. But experience tells me that these folks probably got hooked and dug into whatever side that they're on whenever this trial started, just a long time ago. And this case has it all, like we talked about before, Josh. There's a lot of really bad evidence here for Mr. Penny. And there's also a lot of reasons to acquit him that his lawyers really pounded on too. So again, it just shouldn't be a shock to anybody that this is anybody's game. And there are trials out there that are pretty slam dunkish, right? Cases that you see that are on paper, cases where they have 48 witnesses who all say the same thing, cases that you're trying because the issue is this person going to get the death penalty, or are they just going to get life in prison?
There's no death penalty in New York. That doesn't apply.
This thing really could go either way, and I think by now that should be clear to anybody.
All right, Jeremy Rosenthal.
Well,
thank you.
that was just from moments ago. So that's what he thinks as of this moment. I would have thought very differently. I would have thought this was a slam dunk for the defense originally, but now that we're waiting so long, I don't know exactly what to think anymore. But apparently 39 seconds ago, or actually now it's 5 minutes ago because I played that clip for you, the jury exited. The judge says they'll lunch at 1. It is now 10 minutes to 1. And so we wait. We wait. The other thing that happened yesterday was that the family of Jordan Neely filed a civil suit against Daniel Penny. Here's a clip speaking to that. Actually, this was from this morning, but the civil suit was filed yesterday in the middle of jury deliberations, which is odd timing, in my opinion.
Deliberation set to resume for a 4th day in the trial of Daniel Penny in just a few hours. Those jurors are weighing whether or not Penny crossed the line when he used a chokehold to restrain Jordan Neely for several minutes during an outburst on the New York City subway back in May of 2023. News Nation's Rich McHugh is outside the courthouse with the latest this morning. Rich, what are you hearing? Are we headed toward a hung jury here?
That's certainly the question on everybody's mind. You know, there's obviously a lack of agreement among that jury. They've deliberated for 3 days. They've been very methodical with their questions. Really the only way we can kind of get inside the mind of the jury and see what they're actually thinking is through the questions that they ask the judge. So far they've sent 7 questions to the judge. One of the questions they were asking the definition of recklessness and negligence. They also wanted to rewatch the chokehold video, this nearly 6-minute long cell phone clip of Penny with Neely in the chokehold. They asked to rewatch an alternate, shorter video of the incident shot by a high school girl, Yvette Rosario. It briefly shows Penny and Neely, plus a bystander voice that says, "He's dying, let him go." Rosario testified that she was terrified when Jordan Neely burst into the subway and started threatening. Jury also watched the NYPD body cam footage, which has, firsthand accounts from eyewitnesses on it. The police station interrogation video they got to watch again, which is Daniel Penny in his own words. It suggests they're looking at the justification aspect which is central to this whole case. If the jury can't agree, it could mean a hung jury, which could set the stage for a retrial, Marky.
And Rich, the other interesting thing that dropped this week is that Jordan Neely's dad filed a new lawsuit against Penny this week. What's that all about, and could that have
Yeah, so here's the lawsuit part.
any impact on the case?
Well, it shouldn't, because it's a civil case. This is criminal. It was a case filed in New York Supreme Court by his dad, alleging assault and battery by Daniel Penny that day. So it's a different, unless a jury in this case is watching against the rules, watching the news coverage, it shouldn't have any bearing on this case. In terms of the outcome of that case, well, yes, this case may have bearing on that. It's also a case where they will bring into account the fact that Jordan Neely had a warrant out for his arrest that day from assaulting a woman and 42 prior arrests. So
He had 42 prior arrests, Jordan Neely, and he had a warrant out for assaulting a woman on a subway on the exact day of this incident. Just going to rewind that for a second.
Yes, this case may have bearing on that. It's also a case where they will bring into account the fact that Jordan Neely had a warrant out for his arrest that day from assaulting a woman and 42 prior arrests. So it's very complicated, Marky. Back to you.
Thanks for watching, everybody. Go to joinnn.com to find News Nation on your television.
And I don't know if the jury got to hear about that. I don't know if the jury got to hear about that because, like we've said 100 times, this has not been televised. And so we're getting just bits and pieces from Twitter and other articles that we can cobble together. And I don't know if they were told that. But I want to know. And I also want to know what the judge decided about letting them move on to count 2, because there's no real clarity on that. But it seems to me that if the jury says we're deadlocked on count 1, they should not move on to count 2 based on the wording of the verdict sheet. Apparently 38 minutes ago, he asked the ADA to find some case law on it. And again, not sure what happened. Because, you know, we're not allowed to see what's going on inside the courtroom. And so we're still waiting. Let's go to the chat. Hi, Mama Sheik. Thanks for the 5 prayers up for Daniel Penny. Yep, been praying for days. Been praying for days. I don't know. I don't know what's happening. On top, thanks for your super sticker. The question is also, if they come back hung and they say we're hung and we can't, you know, there's a mistrial, is Alvin Bragg going to choose to prosecute him again? It's interesting because Mayor Adams flipped the other day. I have an article on that we can take a look at. Changed his whole position on this case all of a sudden. Sad already filed a civil suit. Thank you, Lady Di, too. And then someone said here, civil suit, who's paying for that? This civil suits are taken on contingency, which means that the attorneys don't get paid unless there's a settlement. And they often lay out all of the expenses and everything else. So it's not like the family's paying for an attorney. It is like the attorney does not get paid until the case settles, if the case settles. Laura says one person's reasonable is another person's unreasonable. Yeah, it's a subjective standard. Thank you, Laura. Mrs. Bucket, thank you for your super sticker. And can we add I Need a Hero by Bonnie Tyler to, I don't even think we have a playlist up for this case yet. Thanks, Camille, for your super chat. What are you guys thinking? Yes, I did. I knew that Brian Camp proposed to his girlfriend because I reported on that a couple of days ago. But yeah, that's very nice. Very, very nice. This is a state charge. These are state charges. Thank you, Coffee Cake. Good question. Not federal charges. There are never cameras in federal court anywhere. So somebody asked about The P. Diddy stuff isn't that federal court anyway. So regardless of which state that was in, there would be no cameras in court. Yeah, I think this is, where was his family then? 42 arrests and homeless, and he had schizophrenia. There were thousands of pages of medical records, thousands of pages that the defense expert went through before he rendered his opinion that the chokehold was not the cause of death, that the cause of death was a combination of sickle cell trait, the K2 that was in his system, which the toxicology testing cannot even tell how much K2 was in his system. For those of you who don't know, K2 is also known as synthetic marijuana, also known as spice, and it can cause similar effects to cocaine. So the testing for toxicology cannot tell how much of this K2 was in his system. And the defense expert had quite a different opinion from the medical examiner who did the autopsy, Dr. Harris, who testified that she came to a conclusion on a cause of death prior to the toxicology even coming back, that she changed her opinion when she saw a video of the incident. I don't know if she saw it on Twitter or somewhere else. And so her cause of death was the chokehold. But then she admitted on cross that she couldn't even, she couldn't really see from the video how much pressure was being exerted on the chokehold or whether it was consistent pressure. So I had a lot of questions about the medical examiner and her testimony. And yesterday, the jury asked for the cross portion of Dr. Harris's testimony to be read back to them, which I thought, in my opinion, at the time was helpful to the defense. But as you know, you can never, ever, ever guess about what a jury is going to do. You might as well just shake your magic 8-ball and come to a decision. Yeah, she said yes. Isn't that great? I don't know if prior offenses were known to the jurors. If anybody in the chat knows and has been following this like religiously on Twitter or has been in the courtroom, something tells me I don't think so. But what also is interesting to me is that the jury's asking for things like, what's the definition of reasonableness? Read us back the jury instructions. That what the jury is trying to decide has nothing to do with cause of death, which to me would have been the big question, right? If the jury finds the cause of the chokehold did not cause his death, then it's not guilty, right? So who knows what they're talking about in there? And we'll never know unless the jury wants to talk about it, and they are not obligated to. They can, but they don't have to. Let's see if there's anything recent on here for us to take a look at. More recent than what we've already just seen. And this is as of 16 minutes ago, and this is from CBS New York. While we wait for the jurors to eat lunch. And who knows, right after lunch, they may come back and decide, because they're probably talking over lunch. Today's Friday. I'm sure they want to get out of there today. And I think we're going to know more very, very soon.
New York, where jurors are deadlocked in the Daniel Penny trial. Penny, if you remember, is the Marine veteran accused of the fatal chokehold that led to the death of a homeless man on a subway last year. CBS New York has been following this case very closely. Let's listen into their coverage from just moments ago.
Breaking news on day 4 of deliberations in the trial of Marine veteran Daniel Penny. We are now hearing the jury cannot agree on whether to convict him on the most serious charge of second-degree manslaughter.
Penny is on trial for that deadly subway chokehold last year. The jury has been deliberating for 4 days. Doug Williams joins us live outside the courthouse with the very latest. Doug.
Jessica and Cindy, here is the very latest. According to our Alice Gaynor inside the courtroom, just before 11, the jury brought a note to the judge that read in part, "We, the jury, request instructions as we are unable to come to a unanimous vote on count 1. That is the charge of manslaughter in the second degree. It's the more serious charge of the two that Daniel Penny's facing and can mean up to 15 years in prison if convicted. As the judge instructed them at the beginning of deliberations, they must agree on that charge before they can even consider the second charge of criminally negligent homicide. The jury's been told all along that if they were to find Penny guilty of second degree manslaughter, they would not have to issue a decision on the lesser count. So according to Alice just moments ago, this was all just discussed inside the courtroom between both sides of attorneys and the judge. The defense was asking the judge for a mistrial. The judge, it seems, has just instructed the jury and has decided on what's called an Allen charge. That is basically telling the jury to reconsider their positions, to go back to deliberating, to try and come up with a unanimous vote on that first count. We will, of course, keep you updated on this ongoing process going on behind me. But for now, we're live here in Lower Manhattan. Doug Williams, CBS News, New York.
All right, Doug, thank you. And a lot of questions now about how this moves forward.
Joining us to talk more about the case is Fordham law professor Cheryl Bader. Cheryl, this most recent note is our first major indicator of how the jury is thinking. What does it say to you about how they're leaning if they can't even agree on the superseding charge of second-degree manslaughter?
So, of course, deliberation is a secret process, and so we never know what exactly is in the minds of the jury. But when we get a note like this, it can be quite telling. And so there's two different things that we know. One is that there's a substantial disagreement among the jurors, enough so that they're asking the judge to intervene, and that a number of the jurors, and probably a substantial enough number that they're coming to the judge, would be in favor of conviction on the highest count. So we don't know whether that means that other jurors would be in favor of complete acquittal, or if there's been an agreement among the jury and they're just trying to decide, is it manslaughter or criminally negligent homicide?
No, that makes a lot of sense. The latest thing out of the courtroom is really shocking to me because we've known all along they have to agree on the first charge before they can potentially consider the second charge. Now the judge is saying, if you can't come to a unanimous decision on the first charge, we might have to order a completely new trial. Are you shocked by that?
Right. No. So typically, if the jury can't come to an agreement, the judge would declare a mistrial. But here, the judge could ask the prosecution, "Do you want to drop the highest charge?" In other words, again, the prosecutor may be thinking from this note. Again, we're like reading the tea leaves, right? But they may think, okay.
And I think from what we just read from Inner City Press tweeting earlier in the courtroom that Daphne Yoren, the ADA, did say she would be willing to dismiss the higher charge. No word on whether that's happened or not.
There are a lot of jurors here that want to convict. And so am I better off, rather than having to try this case again and have a mistrial, dropping that charge and letting the jury deliberate on the lesser charge of criminal negligent homicide?
So, Professor, do you see this, that we're going to be planning for a longer deliberation?
So I think there'll be at least some more time, because the judge is going to be instructing them that, there's lots of court resources and that they should try to reach a unanimous verdict. And so we'll have them sort of grapple with that again, and then we'll see if there's another note. But then also, I think the judge will be conferring with counsel, especially the prosecutor, to see, do they want to move on to just consider this lesser charge?
All right, Professor Cheryl Bader, thank you so much for your insight. And stay with CBS News New York for continuing coverage. Alice Gaynor is in.
And you were just watching coverage from our partners there at WCBS in New York City. Now, we just learned that the jury is deadlocked on the most serious charge in the Daniel Penny case. Penny, for his part, pleaded not guilty to manslaughter and criminally negligent homicide charges. So let's bring in CBS News legal contributor Jessica Levinson is here with the very
Based on my reading of that verdict sheet, I don't think they should be able to move on to count 2. If they have already are there hung on count 1, I think they should stop, and that should be the end of it. I'm really interested in seeing what happens here.
latest on this case. Jessica, what do you make of this development that the jury just can't come to unanimous decision about the most serious charge here?
I think that the jury is in some ways like the rest of us. I mean, they're looking at a different question, which is just a legal question. We're looking at political and societal questions, but people tend to be divided when they look at this case. And I know that that will upset people who view this through a very specific lens of either absolutely this is inappropriate and in fact it's criminal, or of course we have a Marine here who is just a hero and trying to protect the people on the train. And I think what we're seeing.
Agreed. Yeah, I think in a lot of ways, this case is just as divisive as some of the other cases that we followed recently. Karen Reed, for one. It's either like you think this guy is a murderer, Daniel Penny, and he should go away forever, lock him up and throw away the key, or you feel like he's a hero and what the hell are we doing here? I don't feel like there's really any middle ground here. Let me know. If you're in the middle ground right now, let me know. But I feel like people are either far on one side or far on the other.
Is that our division is playing out in the jury room as well. And we just heard some good information about, why the jury may be deadlocked. We know in our system, we need to have a unanimous jury verdict. The prosecution has to show beyond a reasonable doubt that Penny was guilty of manslaughter in this case. I think it will be really interesting to see when a judge goes and says, can you try again? If anything changes. Why do judges do that? Because as we talked about a few moments ago, there's a lot of resources that go into trying these cases. And a judge is hoping that this isn't all for naught. The prosecution put on the case, the defense put on a case, you have the jurors' time, you have the court staff time, and the judge is trying to save this, say, go back again, take a breath, see if anything changes. And sometimes that works. And then there will be a question, as we heard, about whether or not the prosecution is willing to say, we'll drop that manslaughter charge. Jury, just consider that lesser charge of criminally negligent homicide. And that would be a prosecution decision. Frankly, I think that would involve whether or not they would just rather say this case is basically a loss because it would be a mistrial, and whether or not they want to start from scratch, go back to a different jury with a manslaughter charge, or if they say we sunk so much time into this, it's a tough case, let's try and move forward with this jury where we know at least some of them are willing to convict on the negligence charge.
So it's important to know, Jessica, there's another case that runs parallel to this particular case, and that is the case spawned by Jordan Neely's father, who has filed a civil lawsuit against Daniel Penny. Can you tell us a little bit about what that means in the civil trial?
Yeah, that's a great question. And I think for all of us kind of watching and waiting to see what happens in this criminal case, the bottom line is that that civil case should mean actually nothing, because we are talking about a criminal case where the jury can only consider the evidence that they heard in that case. And so, yes, there is a separate criminal case filed by Neely's family, which we sometimes do see.
Okay.
And obviously the set of facts is the same. The case is different because it's a civil case as opposed to a criminal case. The burden of proof is very different. We have a private plaintiff instead of the government, a prosecutor. But the bottom line for the criminal case is that it should not even really be a question in the jury's mind as to what may or may not be happening in a future or parallel civil case. They are looking at separate criminal acts, and they are looking at different evidence, and they need to make an independent judgment.
All right, CBS News legal contributor Jessica Levinson.
Yeah, and I hear a lot of people in the chat saying, "Well, how can they bring a civil case if he's found not guilty in the criminal case?" Remember OJ. Remember OJ was found not guilty in the criminal case, and then the civil case succeeded, and the families got a huge judgment against OJ, and I don't think he ever paid it. This is just the most recent on Fox Live from a few moments ago. So you can succeed occasionally in a civil case, even though you don't succeed in a criminal case, because the standard of proof is much lower in a civil case. It's preponderance of the evidence, not beyond a reasonable doubt.
Judge that they are unable to report the jury. A range listening into Representative Al Green from Texas there as they are discussing a range of issues. But for right now, we do want to pivot and go out to a live report. The jury in the Daniel Penny trial informed the judge that they are unable to reach a unanimous verdict on the first charge of second-degree manslaughter. The defense emphasized that the jury cannot deliberate on the second charge without result.
If you're not looking at your screen, come look at your screen for a second. Not if you're driving, but if you're doing anything else. This is Jane Rosenberg, a court sketch artist, one of the most famous court sketch artists out there. She's sketched just about every famous criminal defendant out there. I met her when I was at one of the court appearances for Rex Heuermann, the accused, innocent until proven guilty, Long Island serial killer, out in Suffolk County Criminal Court. And we were waiting in line together. She had her giant portfolio. If you're interested in her, Google her. And I think she has a website, and her work is amazing. And it was so interesting to talk to her, because this is really a dying art, because there are cameras allowed in so many courtrooms now that we don't need sketch artists anymore in court. And she is so amazing. She's been doing this, I forget how long, something like at least 40 years. And it's wild to watch her sketch and to see her bringing the courtroom to life for us when no cameras are allowed in and we can't see what's going on. So props and shout out to Jane Rosenberg. And then I did see her when I went to Daniel Penny's trial that day and met her again in the hallway and said hello to her. So she's in the courtroom almost every day. They may switch off. I think there may be 2 sketch artists that rotate, but here's some of her work. You're going to see this sketch and then another one following.
Slaughter. The defense emphasized that the jury cannot deliberate on the second charge without resolving the first, and Penny cannot be convicted of both. Let's bring in Linda Schmidt with our Fox 5 New York team to break down the latest for us. Good morning, Linda. Thank you for joining us here on Live Now from Fox. What's the latest?
Yeah, hi there, Christy. Well, first of all, court just broke for lunch, and they will be resuming the trial at 2:15. When the jurors get back here, they will be in the deliberation room, and they will continue deliberating at 2:15 this afternoon. But they did send a note to the judge at 11:03 this morning saying they were unable to reach a unanimous verdict, a unanimous decision on the first count of manslaughter, which is the more serious count of the 2. And Daniel Penny, if he would be found guilty of that, would face up to the possibility of 15 years in prison. Now, because they are unable to reach a decision on the first count, they are not allowed to move on to the second count.
Oh,
so
good.
They can't even consider that. So as of right now, they are deadlocked. Now, what the judge ended up doing.
All right. I don't know if I should trust this reporter, because so much of what we see is misinformation. But she is saying that if they are deadlocked on count 1, they are not allowed to move on to count 2, which is I think that's the criminally negligent homicide. And they were having a little kerfuffle in court earlier about whether or not the judge was going to allow them to move on to count 2 if they were hung on count 1.
He brought the jury came into the courtroom, and the judge said to them, and I'm paraphrasing here, basically this: look, jury deliberation was never intended to be easy, but it is your responsibility, and you are doing a very good job of being meticulous, going over the evidence, and you have been deliberating since Tuesday afternoon, which is a long time, but it's not too long. So I need you to go back in, and I need you to continue deliberating. Now, when the prosecution, when the note first came into the judge and the prosecution read that note, their response, the prosecutor smiled, grinned. But it was not a happy grin, of course. It was a grin of, I cannot believe that I'm actually reading this, that they cannot reach a verdict, and that they are not allowed to move on to considering the second count without reaching a unanimous verdict on the first count. In fact, she said it is crazy that they are not allowed to move on to the second count. But
It's
again,
crazy
they
that
are
you
going
think
to
they should be
continue
allowed to.
deliberating. Right now, I'm going to bring in an expert, criminal defense attorney, Arthur Aidala. He comes in and he gives us his
All right. Anybody but Big Case Mike. All right. I'll allow it.
expert opinions on a lot of these cases. We've covered a lot of serious cases, big high-profile cases together, and I do appreciate you being here again, Arthur.
Well, it's my pleasure.
So now, at this point, they've broken for lunch. They are still deadlocked. As a judge, What do you think happens at this point? What do you think's going on with the jury?
Well, technically, while they're having lunch, they're not even supposed to deliberate. Usually the judge tells them that, even though they're all in the same room.
See your jump back.
And Linda, as you know, like human nature takes over a lot, right? So you have this big job to do, and there's all 12 of you, and you're all there with a sandwich. So I don't think it's very likely they're not chit-chatting about it.
Yeah, of course, they want to go home.
What you
It's
said
Friday.
earlier is accurate. They're working on this. So they said they were hopelessly deadlocked. The judge said to them, you got to try to keep working. And then within minutes, they came in and said, okay, we want the definition of a reasonable person, because that's part of that manslaughter in the second degree, the top count. That's part of that charge. So the judge brought them in and told them, and there's a book that we use that says a definition of what a reasonable person is. He gave them that, and now they're going back in to deliberate. You don't know exactly what's going to happen next, but they're clearly working.
Right. And the reason that they wanted to get a definition of the word reasonable is because in the count, they have to decide, would a reasonable person, somebody else, reasonably, would they have reached the same decision that Daniel Penny did in handling that situation? And are his actions reasonable for the average person?
Right. And the thing is, everyone's definition of reasonable.
John, he already gave the Allen charge. We went over that earlier and we read the Allen charge. So if you're behind, you can rewind, but he did give the Allen charge. And now the jury's back deliberating, or at lunch actually right now.
Reasonable for themselves may be a little different. And so you have to kind of just look at it. Look, when we pick jurors, we always say you need to use your common sense. You need to use your common sense.
Right.
So in your common sense, was that reasonable under the circumstances? And, that may really be what they're fighting over. That's what they're deliberating over, and they can't agree on that top count. And if they can't agree on that top count, as of right now, they can't deliberate on the lower count of criminally negligent homicide.
Okay, so they're going to resume at 2:15 after the lunch break. And what if an hour or two goes by and they send another note to the judge saying, we just cannot reach a consensus, a unanimous verdict here on the top count?
So if that happened, the defense would definitely move for a mistrial. Definitely say, Judge, they can't do it. They've been here all week, and we have to move on. The prosecutor would say, no, Judge, have them keep working. And then it's really the judge's decision. He's got one of two things. He could say, okay, we're throwing in the towel, and this will be another juror's and another judge's problem somewhere down the road. Or he could say, look, you guys worked very hard all week. I'm sure you're all a little tired. Why don't you everyone go home for the weekend, get some rest. No. Don't pay attention to any media.
No, don't do
talk
that.
about the case with anyone in your family, and come back Monday and start deliberations anew.
Okay, because they really have been meticulous going over this evidence. I mean, everything that they've asked the judge for, whether it was a read back from some of the witnesses, two of the witnesses, in fact. One was the man, the freelance journalist, who actually shot that chokehold video in the subway that went viral, that everybody has seen since May of 2023. The other was a shorter video that a high school student who was on the subway shot. And she said she was so scared that day that she thought she was going to pass out. But also in that video, you can hear a couple of the other passengers saying to Daniel Penny, let him go.
Bada bang.
He's dying.
Right. But, they didn't testify, those other passengers, I don't believe. She did.
Yes, she did.
And, that goes into what's reasonable. So if you see another human being so scared that they're shaking like this young lady was, and you're Daniel Penny and you're physically fit to the point where you could prevent something from happening, is it reasonable for you to act? And then was it reasonable for you to hold on to that person for as long as you did? And clearly that's what the jurors are tussling with as we speak. If they come back in with that hung note, the judge can say, you're okay, it's over, or can say, come back again on Monday. Usually judges try to get a verdict. Usually they try to get a verdict, because the only thing that's going to happen is you got to do all of this all over again. So it's up to the judge.
Okay. All right, Arthur. A pleasure.
Thank you very much.
Thank you
Very
so much.
interesting.
Yeah.
I love this guy. Bada bing, bada boom. He's like Tony Soprano. I love him. I love his accent. It is 34 degrees in New York today with a real feel of 25 degrees because it's very windy today and it's freezing cold. Here's why I'm having a little bit of a disconnect here, is because on November 18th, you may recall, I did a live stream. And it was breaking news, and there was a very similarly situated man who was homeless, had a history of mental illness, and also, I believe at the time, had a warrant out for his arrest on November 18th, running around New York City with a couple of butcher knives, and he stabbed 3 random people in 3 different places throughout New York City. One all the way on the west side in Chelsea, a construction worker at 8:30 in the morning in broad daylight. He was killed. Then he went over to the east side down by the old water club and he stabbed a man who was fishing to death, and then moved on closer to the UN building where he stabbed a 36-year-old woman who, at the time I went live with that story, she was fighting for her life in a New York City hospital, and she died during the course of that live stream. And so we're all saying to ourselves, well, nobody's going to step in because, Daniel Penny's on trial right down the street for stepping in. And then yesterday, was it yesterday already or the day before? Because the days are all sort of blending together. We watched a CEO of United Healthcare, Brian R. Thompson, be assassinated at 6:46 a.m. right in front of the Midtown Hilton Hotel. So the jury's not supposed to be listening to the news, at least with regard to the Daniel Penny case, but there's no way in hell that they have not heard about these other two things that went on in Manhattan during the time that their trial has been going on. And so I can't understand why they're having such a hard time, because there is no good Samaritan law in New York, and people in New York need people like Daniel Penny around. If I was on that subway car, if my children were on that subway car, I would be giving him a medal and a hero. And you heard, and we went over portions of this trial together, and we've caught up on it for the most part. And we saw some of the witnesses' videos, and we read about some of their testimony. And these witnesses on the train were in fear for their lives. There was a woman who testified that she had ridden the train for 50 years. And this was the only time she really thought she was going to die on a subway car. And listen, you're on a subway car that's in between stations. You have nowhere to go. There's no escape. So to me, this is a slam dunk case as a New Yorker, as a mother, as a person who rides the subway. And so I don't understand. I don't understand what's going on here. They heard about the drugs in his system. They heard about the things that he shouted when he, pulled apart the train doors to get on. If I don't get some money or some food, I'm going to kill somebody. I don't care if I don't care if I go back to Rikers. I don't care. And screaming and yelling. And Daniel Penny said, and we watched his interrogation video, which, by the way, if you have watched his interrogation video on your own and you weren't here for my commentary of it, Daniel Penny, at the time he was interrogated, did not know that Jordan Neely had expired, which is a nice way of saying died. He did not know, because guess what? We saw other footage of the first responders responding to the subway car and coming on the subway car. And we saw at least 3 or 4 of them say, we've got a pulse, we've got a pulse, we've got a pulse. And then we talked about the testimony of the sergeant of the NYPD who got up there and said, I was not going to allow any of my guys and girls, because there were women first responders as well, to give this dirty homeless man mouth to mouth or any type of close-up life-saving measures, because I didn't want them to catch, and then he caught himself and said hepatitis or anything like that and bring it home to their families. So in my opinion, Jordan Neely was still alive when the first responders got there. And if for perhaps very good reasons, they did not want to perhaps give him the life-saving measures that a very close person might have, like when Karen Reed gave John O'Keefe mouth to mouth at the scene. How about don't jump on a train and threaten to kill people? How about that? How about that? Thousands of pages of mental health records that the expert went through for the defense. Thousands of pages. This guy had 42 priors, including an outstanding warrant for assaulting a woman on the subway. Let him go home today, but he's been out on bail the whole time. That's important to point out. Daniel Penny has not been in custody. He's out on $100,000 bail. He posted $6,000 cash, and his parents, I think, guaranteed the balance of his bail. And this is just, if this is a mistrial and this Alvin Bragg decides to re-prosecute, this is going to be a mess. It's going to be a mess. And I'm telling you here first, because I firmly believe that. I already am afraid for what's going to happen today outside the courthouse. If, no matter what happens, if it's a mistrial, it may be a little bit more sedate or neutral out there. But if it's a not guilty or a guilty, who knows what's going to happen? Here's an article from the Post a couple of days ago. This came out to see if there's anything new. Well, you know what? Let's give Inner City Press his 5 minutes right here, or his 1 minute, because he went outside to do a lunchtime video. So please go follow him on Twitter, because he's like boots on the ground, and he's the one who's live tweeting all of this for us from inside the courtroom. He's got his phone there. In some other cases, like in the Karen Reed case, when I went to that trial, we were not allowed. Nobody was allowed to have their phone in there, and a lot of courtrooms are like that. You have to, like, you don't have to put your phone in a Faraday bag when you come in or anything, but you're not allowed to have it out in the courtroom at all.
Okay, here we are, Matthew Russell Lee, Inner City Press. Now, we just stepped out of the Daniel Penny jury deliberations. Things have come to a head. In the late morning, the jury sent out a note saying that they're deadlocked on count one. And according to the instructions that were given to them, you had to decide on count one before moving on to count two. The defense asked for a mistrial. This was denied. The judge, Judge Wiley, has said he gave them an Allen charge, saying go back and deliberate, don't try to be flexible. But he's indicated that he believes that he can move on to count two. And the Daphne Uran, the prosecutor, has said that they might be willing to dismiss count one to move it on to count two. Now, there's the instructions, and there's also a provision of the Criminal Procedure Law of New York that we put up, and there's some cases, but it will re-begin at 2:15. And we'll see what's going on. Inner City Press, we covered it. We wrote a book about the evidence phase of the case. It's called Daniel Penny for Your Thoughts. Will there be a second one? If this keeps going, there'll definitely be enough material. In any event, Inner City Press remains on the case, innercitypress.com.
All right, right on, innercitypress.com. Give him a like and a follow and all the props, because he's doing it. He's doing it for us. He's there. Bandit's mom never liked the subway. Riding a train to a Soxy has been hyper alert. Lori Jean, Hank stole Lally's lunchbox, the good one from Canada. Is it up to the judge as to whether or not the trial is live or closed, meaning whether or not cameras are allowed in? Yes. They are typically never allowed in New York, but I do know that during the Rex Heuermann arraignment and during other parts of the trial, they always make motions to allow the cameras in. The judges typically always say no, although they do allow a still photographer in, a pool photographer. And last time I was there, it was the Newsday photographer. Sometimes it's the Post photographer. It depends. And then they share the photos. It's usually only still photography that's allowed inside New York state courtrooms. Thank you for the 5. And again, is it up to the judge to decide whether or not the trial is public or private? So different question, meaning can anybody who's in the public just go sit in the courtroom? Yes. That is not up to the judge. Anyone can go sit in the courtroom. So if you are in New York and you want to go watch a trial, you can go watch. The day that I went to the Daniel Penny trial, there were only 30 seats available to the public. So because I got there late, I had to wait in line outside until people left. But there was only like 2 people in front of me. And after waiting for like an hour, I was able to get in and get a seat in the back of the courtroom. So courtroom proceedings are public, but with regard to cameras, typically they're not allowed. Hope that answers your question. I'm just a girl in the world. Thanks for the 10. Isn't it common to have a charge drop during deliberations? Given that a not guilty on charge 1 would stop deliberations, this feels manipulative to me. Yeah, I mean, I'm sure that the defense is allowed to object and be like, no, it's either count 1 or nothing, because they know they're already heading toward a mistrial. So it's not, I don't think it's that common, but nothing is surprising me anymore in these trial watching things that we're doing, because I don't know. I don't know what the judge is going to allow them to do. But if I was the defense, I would object to that. It does feel manipulative. Thank you for your 10. And then another 5. Is that the same question as the first one? I think so. Thank you. Thank you. I'm just a girl in the world. Makes me wonder, says, I hope Daniel would be found not guilty and is home for Christmas. Well, he's been home the whole time. So yes, I agree. I don't think that because if he's found guilty, he will be cuffed and brought into custody. So that would be insane and crazy and horrible, in my opinion. And I think this is the same question that we just went over, whether the trial is public or closed. Anybody can go sit in a U.S. courtroom as long as there are seats. Remember in the Karen Reed trial, okay, I have to correct myself, because in Karen Reed, the courtroom was so small that there were 10 seats for the victim's family, 10 seats for Karen Reed's family, and 10 seats for media. There were no public seats available because the courtroom was so small. Kitty Genovese, Queens, New York in 1964. Jenny, I brought that up one time. Thanks for the 5. And I remember learning about that in social studies when I was like in 8th grade. And the original story was that Kitty Genovese was a woman who was essayed like on the street in Queens, Forest Hills, as a matter of fact, I believe. And that people were looking out the window and nobody tried to help or call the police. And then since then, I've been corrected and told that that was completely debunked and that people actually did call the police and did get involved. So, yeah, I mean, that was the seminal case as far as when I was all the way back then in 8th grade social studies. But I think since then, it has been somewhat debunked. But thanks for bringing that up. Oh, you had a typo, so you did it twice. I know what you're saying. I always know what you're saying. Hoslong is their lunch break. Hoslong from Canton. They said they're coming back at 2:15. Did my sound just cut out? I feel like my sound just cut out. 2:15. They're coming back. Can you imagine the tragedy if Penny never stopped to help? All right, I think my sound is still working, but it sounded to me like it cut out. Cat Lady says, this should not be taking so long. He is not guilty. This is disgusting. Hope Bragg gets voted out. Well, it's insane. It's insane. I agree. Here's the here's Mayor Adams flip-flopping his stance the other day. Mark says, just want to thanks for all you do. Big fan from Boston. Thank you. Grab a coffee, but it's got to be iced. I know. I do love my iced coffee. Usually I dump it all over the carpet. Mark knows. Mark knows. You know what I'm saying. So here's what Mayor Adams said a couple of days ago, which I thought was a little telling and a little weird. And all of a sudden, because I had said during one of our last live streams on this, I think it was during the live stream of when the guy with the knives was running around New York City killing those people on November 18th, apparently. I said, how come Mayor Adams isn't making a call to his friend, Eric Adams isn't making a call to his friend, Alvin Bragg, and saying, hey, dude, drop those charges. Dismiss the charges. I don't know. But this was from December 3rd, which is, today's the 6th. So this was Tuesday's New York Post. Mayor Adams hopes Daniel Penny jury will make the right decision in New York City subway chokehold trial. Mayor Eric Adams defended Daniel Penny as a Manhattan jury on Tuesday started deliberating whether to convict him of choking a troubled homeless man to death on the subway, insisting the Marine veteran was doing, quote, what we should have done as a city. Was he watching my show on November 18th? I don't know. His Honor said he hopes jurors would make the right decision in the lightning rod case as he blasted the failure of the Big Apple's mental health system for not doing more to help Jordan Neely in the lead up to the fatal 2023 subway encounter. The young man in this case was going within our system throughout the revolving door of our system. Now we're on the subway where we're hearing someone talking about hurting people, killing people, Adams said Saturday on WOR's The Rob Astorino Show. And there's Mayor Eric Adams, who himself is under some threat or perhaps federal charges. You have someone on that subway who was responding, doing what we should have done as a city in a state of having a mental health facility, he added. Those passengers were afraid. I've been on the subway system. I know what it is. As a police officer, to wrestle or fight with someone, it's imperative that we look at the totality of this problem, Adams said. Adams went on to say that he hoped jurors would, quote, hear all the facts as they consider whether the 26-year-old former Marine was justified in restraining 30-year-old Neely, who had a history of mental illness and drug abuse following his outburst on the crowded F train in May of last year. Quote, based on all the facts that's laid out, a jury of his peers will make the right decision. I don't want to prejudge that. Adams said of whether Penny should be found guilty of manslaughter and criminally negligent homicide. That could have easily been a case where you saw 3 innocent people murdered on our street 2 weeks ago. Ding, 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 he said, referring to a recent deadly stabbing spree in Manhattan on November 18th. We have to recognize we have a mental health crisis. We're not doing enough to solve it. So there's Mayor Adams flip-flopping on the Daniel Penny case. So there's that. Back to the chat. What's the atmosphere outside the court? Well, it seems that all the protesters, at least the day that I was there, all of the protesters who were outside the court in the morning were inside the courtroom watching the trial. So I don't know what's going on today because nobody's really covering it live, except for Fox, and they're not coming back until 2:15 from lunch. So we may just break until 2:15 and then come back when something breaks. So you're going to want to make sure that you hit the subscribe button. You're going to want to make sure that you hit the bell so you know when I go live. You're going to want to just be looking out for it. We're going to take a break, give the mods a break. And if you were not here for the beginning of the stream, go back and watch it because we read the Allen Charge. Some people are asking, what is an Allen Charge? We read the Allen Charge. We took a look at the verdict slip. And we talked about some other things that happened in the courtroom this morning. Thanks, Charlie Lynn says, this is outrageous. If he did not act, they'd slam him too. Darned if you do and darned if you don't. Mm-hmm. Yeah, funny the way it is, if you think about it. Right? Funny the way it is. Set your notifications, people. Make sure you have them also set on your phone. Because it may happen right at 2:15, it may not. So we may just wait until it happens, and then we're just going to go live at the time that it goes live. All right. And there's also been a lot of confusion out there about whether or not when President Trump comes into office, whether he can pardon Daniel Penny if he's convicted. The answer is no, he can't. These are state charges, not federal charges. So there seems to be some confusion about that. The president cannot pardon someone from state charges. You also can't pardon someone unless they're actually convicted of something. You can only pardon someone who is convicted of federal charges. Let's get to 100,000 subscribers. Come on, it's free. It's free. I hope they don't find him guilty because of all the pressure to come to a unanimous verdict too. Those of you who are following Karen Reed with me, I listened to episode number 9 today of the Phelps podcast, and I've got a whole show planned about that for later, but we got to wait until after we have some sort of a decision on Daniel Penny before I can even start thinking about that one because I have all the thoughts rolling around in my head. So we're going to be very, very busy today. Very busy today. Make sure you have that thing set to go and just be ready. Be following Inner City Press because as soon as he says it's go time, it's going to be go time here as well. So until then, my friends, stay cool, stay kind, stay classy. Be safe out there. And if you're getting on the subway today, good luck. Daniel Penny's busy today. So there's that. Peace, my friends. I'll see you real soon. Prayers up for Daniel Penny.